Hi there. This is Jonathan Ratchik. I'm a partner at the law firm of Kramer, Dunleavy Ratchik here in New York City, a plaintiff's personal injury law firm. So if you've been injured and I hate using this word, in an accident and you are pursuing a lawsuit, you've probably heard or received a notice telling you that you have to appear for what's called an independent medical examination, often short by called an IME. And that phrase can sound reassuring, right? It suggests that perhaps there's a neutral doctor who's simply going to take a fair look at your case and your injuries. But in every one of these cases, the examination is arranged and paid for by an insurance company or defense counsel. And the doctor is selected by and paid for by them to evaluate you. So today I want to talk to you about what to expect in an, again, IME, and I put that in quotes for a reason, why you are required to attend one, what you should expect when you attend one, and why these examinations are anything but independent. So at its face value, an independent medical examination is a medical examination performed by a doctor who is not your treating physician. Okay. The doctor is not there to treat you or to help you, to prescribe any medication to, or a course of treatment, or in any way, shape, or form help you on your recovery. Okay. The sole purpose of this examination is to evaluate your claim from the perspective of or your claimed injuries from the perspective of the defense and the insurance company. So in New York State, if you bring a personal injury lawsuit, if you affirmatively place your physical condition in controversy, okay, whether it's physical or mental, the opposing side has a right, which they will always exercise, to have you examined by one or more physicians. Okay. In other words, if your physical exam or physical condition is part of the case, which it is in every personal injury lawsuit, the other side is going to ask to have a doctor examine you, okay, and prepare a report. And if the case proceeds to trial, testify on behalf of the defendant. Okay. So and sometimes specifically in automobile cases, an IME might actually also come up in the context of receiving no fault benefits. An insurance company is only required to pay no fault benefits to the extent that they are reasonably necessary, okay, to aid you in your treatment and your recovery. And so an insurance company will oftentimes have a claimant seen by a doctor for an IME to decide whether or not you are still entitled to receive no fault benefits, okay, or whether your injuries are whether you're entitled to continue receiving no fault benefits, okay. And usually what happens is that once they have that examination, the doctor says that you don't need therapy or treatment anymore, and the insurance company does not pay for any future benefits. So regardless, even though these are not independent, okay, even though doctors are not there to help you, you still have to attend the physical examination. Okay. Again, if you're making a claim for personal injuries, your medical condition is in controversy and an issue, and they are entitled under the law to have you evaluated by, again, one or more physicians to assess the nature and extent of your injuries. And the medical examination, or the physical examination, as I like to call them, is one of the tools that they use to do that. And if you don't appear for this examination, a physical examination with the defendant's doctor, it can potentially create some serious headaches for your case. Okay. And if you violate one or more court orders and you get the wrong judge, the court might preclude you from proving any of your physical injuries at trial, and which essentially amounts to a dismissal of your case, especially in the context of a motor vehicle case. Or if you don't appear for a medical examination in the context of receiving no fault benefits, the insurance company can cut you off of any future benefits, or to the extent that they haven't paid for any benefits yet, stick you with all of the medical bills for your treatment. So what do you expect during one of these exams? Okay. So first of all, this is going to be a lot different than a visit with your own doctor. Again, these doctors are not there to care for you or to treat you. Their sole job is to evaluate you, prepare a report for the other side to be used in connection with defending your lawsuit. So typically when you show up, there's an intake portion and there's a physical examination portion. Okay. So when you show up, you're going to be asked questions that relate to how the incident occurred, what your medical treatment was, what your current physical complaints and symptoms are, okay, how your injuries affect your daily activities, your enjoyment of life, etc. Okay, you might also be asked to fill out a questionnaire relating to all these different issues. And then the doctor is going to perform a physical examination. Okay, it can be an orthopedic exam, a neurological exam, whatever specialty the doctor is, that's the exam they're going to perform. Okay. And typically, in the more common for an orthopedist, they're going to conduct range of motion examinations, testing your strength, neurological examination, checking your reflexes, asking you to perform certain movements, assessing your range of motion. Okay. And all of these things, it might not take that long. These might not be the most thorough examinations in the world. Okay. I've had more than a few clients report back to me that the defendant's doctor's examination of them, the actual physical exam, can be less than 5 minutes sometimes. Sometimes they're more extensive, but oftentimes they are not extensive or not extensive at all. Okay. The advice that I give clients when they are appearing for a physical examination, it's really to be honest, be consistent with your deposition. Okay. Because these examinations almost always happen after a plaintiff's deposition or examination before trial. Okay. The symptoms that you relate at your IME should mirror in large part the same symptoms or complaints that you made at your deposition. Okay. If something hurts, say so. Okay. If you can't do a certain movement, don't attempt to do it if it's beyond your limits. Okay. And it's certainly, again, better to say that you don't remember something rather than to guess. You don't have to exaggerate your injuries. For the most part, your medical records will speak in large part to what your condition is. Just be consistent with your deposition about what hurts, what bothers you, what you can't do at all, what you might have difficulty doing. But just remember, from the time that you enter that room until the time that you leave it, that doctor is not there to help you. Okay. They are there to help the defendant and the defendant's insurance company. Okay. And they're going to be observing you from the moment you walk in to the moment that you leave. Okay. They're going to assess your movements, perhaps in the waiting room. They're going to be looking at how you get on and off the exam table. They might even wonder how you got to the appointment. If it's not a convenient location, did you take mass transit? Did you need a car service? Did you drive yourself? But always you can be polite, be cooperative, and treat the appointment seriously. Okay. And again, how to prepare for one of these exams. Ultimately, it's the doctor is the one performing the examination, and they will presumably give you a roadmap as to what information they're looking for. But again, just be consistent with the complaints that you made at your deposition, or what your deposition testimony was about your physical symptoms, about how your injuries have affected you, etc. And just make sure to relay those same complaints and symptoms to the doctor at the examination. Okay. And oftentimes, before you fill anything out, I always send a representative to accompany my clients to one of these examinations, because I don't like these doctors to overreach. These doctors, they love, especially in the context of motor vehicle accidents or even slip and fall cases, they love to overreach. They love to ask questions about how the incident occurred, about prior unrelated injuries or surgeries. And so you don't want to get tripped up for something like that. Okay. So if something doesn't feel right and you don't have a representative there, take a pause, call your lawyer, and make sure you understand fully what you're doing before saying something or even signing something. Okay. Because the last thing you want to do is create a headache for you at one of these examinations by perhaps disclosing something that you should not have disclosed. Okay. I want to reiterate again that these independent medical examinations are anything but independent. Okay. These doctors are handpicked and paid by the insurance company. They are not there to treat you. They are not there to help you. They are there to minimize your injuries. Okay. Oftentimes, you're going to say that your injuries are resolved, or if they're not resolved, that the incident in question is not the cause of your injuries, that they were pre-existing or related to something that has nothing to do with the case, okay, or the defendant's negligence. Okay. It doesn't mean that they're necessarily dishonest, but it does mean that the examination is not there to treat or help you. Okay. They're not there to give you a second opinion, and it's certainly not a confidential examination to help you feel better. All right. So, but again, these doctors, they're there to say that your injuries have resolved, that you can go back to work, that you don't need additional treatment, that your symptoms aren't related to the trauma. Okay. Because that's how the insurance company and the defense counsel, that's how they're going to defend the case if it goes to trial. Okay. And these are the true defenses that they're going to raise in the event that your case does go to trial. And that's why, again, preparation is so important for these examinations. And it's why you really should speak to your attorney before attending it, so that you understand what to expect and that everyone's on the same page. So again, if you receive a notice for one of these examinations, whether it's for a no-fault exam or for in the context of a personal injury lawsuit, don't panic. but you can't ignore it. Okay. Make sure you speak to your attorney about it, calendar the date that you attend it, and make sure that you understand what is going to happen when you're going to be there. Okay. So again, at Kramer, Dunleavy, and Ratchik, we represent injured New Yorkers and help them throughout every stage of the civil litigation process. And that includes what to expect when attending one of these medical examinations. If you have personal injuries about your claim or you want additional information, feel free to contact my firm and we would be happy to speak to you and help you understand what your rights are. Again, Jonathan Ratchik, Kramer, Dunleavy, and Ratchik, experience you expect, commitment you deserve.